Let me ask you a question. If you are 18 years old in America, you can vote. You can serve in the military, you can get married, you can sign contracts, you can buy a rifle or a shotgun, but you cannot buy a handgun. Does that make sense to you? For over 50 years, federal law has prohibited anyone under 21 from purchasing a handgun from a licensed dealer. It is one of those laws that most people do not think about because it has been around for so long. But right now, that law is being challenged in federal court, and there is a very real possibility it is going to be struck down as unconstitutional. If that happens, it would be a massive change affecting millions of young adults across the country. So let me explain where this law came from, why it exists, why it is being challenged now, and what it would mean if courts decide that 18 to 20-year-olds have the same Second Amendment rights as everyone else. Let me start with the history, because context matters. The federal law prohibiting handgun sales to people under 21 was passed in 1968 as part of the Gun Control Act. This was a turbulent time in America. There had been major political assassinations. Crime rates were rising. There was a lot of social unrest. Congress wanted to do something about gun violence, and one of the provisions they included was raising the minimum age for handgun purchases to 21. The logic was that young people are more impulsive, more likely to commit crimes, and less responsible with firearms. So by preventing 18 to 20-year-olds from buying handguns, the government thought it could reduce youth violence and keep guns out of the hands of people who were not mature enough to handle them responsibly. That was the theory anyway. And for over 50 years, this law has been in place without serious legal challenge. Courts upheld it. The public generally accepted it. It became part of the background of American gun law. But here's the thing. Just because a law has been around for a long time does not mean it is constitutional. And just because something seems reasonable from a policy perspective does not mean it is legally justified. That is what we are finding out now as this law faces new scrutiny in the wake of the Supreme Court's Bruen decision. Remember, Bruen established that gun laws have to be consistent with the historical tradition of firearm regulation in America. You cannot just say a law serves public safety. You have to show that there is historical precedent for that type of restriction going back to the founding era. And when you apply that test to the federal law, prohibiting handgun sales to 18 to 20-year-olds, you run into a serious problem. There's no historical tradition of treating young adults as second-class citizens when it comes to gun rights. In fact, the historical evidence points in the opposite direction. Let me explain what I mean. At the time the Second Amendment was adopted in 1791, 18-year-olds were considered full adults with all the rights and responsibilities that came with adulthood. They could vote in most places. They could serve in militias, which was a civic duty expected of able-bodied men. They could own property. They could enter into contracts. And yes, they could own and carry firearms without restriction. There was no concept of treating 18 to 20-year-olds as a separate category of people who had limited rights. In fact, many of the founders and prominent figures in early American history were doing significant things in their late teens and early 20s. Alexander Hamilton was a military officer in his early 20s during the Revolutionary War. James Monroe was wounded in battle at age 18. The idea that people in this age range are not responsible enough to exercise constitutional rights would have been completely foreign to the founding generation. So when courts apply the Bruen test to the federal handgun purchase age limit, they have to ask, is there a historical tradition of prohibiting young adults from buying handguns? And the answer is no. This restriction is a 20th century creation. It does not have roots in the founding era or even in 19th century gun regulation. And that is a big problem for the government trying to defend this law. They cannot point to analogous historical restrictions. They cannot show that the founding generation thought it was appropriate to ban 18 to 20-year-olds from buying handguns. The historical record just does not support it. Now let me tell you about the specific case that is challenging this law. It is called Frazier versus Bonta, and it is being litigated in California, though it challenges federal law. The plaintiffs are young adults between 18 and 20 who want to buy handguns for self-defense but are prohibited from doing so by federal law. They are arguing that this prohibition violates their Second Amendment rights. And they are using the Bruen framework to make their case. They are saying, show us the historical tradition that supports treating 18 to 20-year-olds differently when it comes to gun rights. And the government has struggled to provide a good answer. The case has gone through various stages, and so far, the arguments on the gun rights side have been pretty compelling. Legal experts who follow Second Amendment litigation closely think this law is vulnerable and could very well be struck down. If you are 18 to 20 years old and you are just now realizing that your Second Amendment rights might be about to expand significantly, do me a favor. Hit that like button right now. Subscribe to this channel because we are covering the legal changes that affect your rights. And share this video with your friends in the same age group because they need to know what is happening. All right, let us keep going. Now let me address the arguments on the other side, because this is not a one-sided issue. People who support the age 21 restriction make several points. They say that 18 to 20-year-olds have higher rates of impulsive behavior and are statistically more likely to commit violent crimes than older adults. They point to brain development research showing that the prefrontal cortex, which is responsible for decision-making and impulse control, is not fully developed until the mid-20s. They argue that even if there is no historical tradition of age-based restrictions, modern understanding of psychology and public safety justifies treating young adults differently. And they worry that if 18-year-olds can buy handguns, it will lead to more youth violence, more suicides, and more accidental shootings. These are serious concerns, and they reflect genuine worries about public safety. But here's the problem with those arguments from a legal perspective. Under the Bruen framework, modern policy preferences and social science research are not enough to justify restricting constitutional rights. The court was very clear about this. You cannot just say we have good reasons for this restriction. You have to show that the restriction is consistent with historical tradition. And the historical tradition does not support age-based gun restrictions for adults. 18-year-olds were considered adults at the founding, and they had the same rights as everyone else. So unless the government can find historical evidence that the founding generation thought it was appropriate to restrict gun rights for young adults, the law is going to have a hard time surviving judicial review. There is another angle to this that makes the current law even more questionable. Right now, 18-year-olds can buy rifles and shotguns from licensed dealers. They just cannot buy handguns. But handguns are the most common type of firearm used for self-defense. They are compact, easy to use, and practical for home defense or concealed carry where legal. So the current law essentially says you are old enough to buy a long gun, but not old enough to buy the most effective tool for self-defense. That creates a strange and arguably irrational distinction. If the concern is that young people are not responsible enough to own guns, why can they buy rifles? And if they are responsible enough to buy rifles, why not handguns? The inconsistency undermines the government's argument. Let me talk about what would happen if this law gets struck down. If a federal court rules that the age 21 handgun purchase restriction is unconstitutional, 18 to 20-year-olds would be able to walk into a gun store and buy a handgun just like anyone over 21. They would still have to pass a background check. They would still be prohibited if they have a criminal record or other disqualifying factors. But age alone would no longer be a barrier. This would be a huge change. There are millions of people in the 18 to 20 age bracket in America. Many of them live on their own. Many of them work, pay taxes, and have all the other responsibilities of adulthood. And many of them would like the option to own a handgun for self-defense. Right now, they are told they have to wait until they turn 21. But if this law falls, that wait disappears. Now, some states might try to pass their own laws raising the handgun purchase age to 21 at the state level. But those state laws would face the exact same constitutional challenges as the federal law. If courts say that prohibiting 18 to 20-year-olds from buying handguns violates the Second Amendment, then it does not matter whether it is a federal law or a state law. The Constitution applies to both. So even if some states try to maintain age restrictions, those restrictions would likely be struck down in court as well. The end result would be a nationwide recognition that 18-year-olds have full Second Amendment rights, including the right to purchase handguns. Let me address a concern that some people have. They worry that if 18-year-olds can buy handguns, there will be an increase in gun violence among young people. But let me point out something important. In many states, 18-year-olds can already possess handguns, even if they cannot buy them from dealers. They can receive them as gifts. They can buy them in private sales in states that do not require background checks for private transfers. So it is not like 18-year-olds are completely cut off from handguns under current law. They just cannot buy them from licensed dealers. What striking down the federal law would do is allow them to go through the same background check process as everyone else when purchasing from a dealer. In some ways, that actually creates more oversight because dealer sales involve federal background checks, while private sales often do not. Here's another point. 18-year-olds can join the military and are trained to use firearms, including handguns, as part of their service. They are trusted with their responsibility of defending the country, sometimes in combat situations. But when, hey, come home, federal law says they are not responsible enough to buy a handgun for personal protection. Does that make sense? We trust them with military weapons in war zones, but not with handguns for self-defense at home. That contradiction is one of the reasons courts are skeptical of the age restriction. Let me give you a timeline for when we might see a decision on this. The Frazier case and other similar challenges are working their way through the courts right now. It could take another year, or even two, before we get a final ruling, especially if the case goes all the way to the Supreme Court. But the momentum is clearly on the side of the challengers. The Bruen decision created a framework that is very favorable to this type of claim. And unless the government can come up with historical evidence that nobody has found yet, it is hard to see how the age restriction survives. So if you are 18, 19, or 20 right now, there is a good chance that by the time you are 21, the law will have changed and the age restriction will be gone. Let me take a moment here to ask you again. If this video is giving you insight into a major legal change that could affect millions of young adults, please hit that like button and subscribe to the channel. Share this with anyone in the 18 to 20 age group who cares about their rights. This is important information. Most people have no idea this case is even happening. All right, let us keep going. Now let me talk about the broader implications of this case. If courts strike down the age restriction on handgun purchases, it opens the door to challenges against other age-based gun restrictions. For example, some states prohibit people under 21 from obtaining concealed carry permits. If 18-year-olds have a constitutional right to buy handguns, do they also have a right to carry them for self-defense? The logic of the Bruen decision would suggest yes, and that means state concealed carry age restrictions are probably going to be challenged and potentially struck down as well. We could be moving toward a legal environment where 18-year-olds have the exact same gun rights as people over 21. That would be a significant shift in American gun policy. There is also a broader conversation here about how we define adulthood in America. We have created this strange in-between status for 18 to 20-year-olds where they have some rights of adulthood but not others. They can vote, serve in the military, and be held fully criminally responsible for their actions. But they cannot buy handguns, and in most states, they cannot buy alcohol. This patchwork of different age thresholds for different rights creates confusion and arguably treats young adults unfairly. The legal challenges to gun age restrictions are forcing us to reconsider these inconsistencies. If we say someone is an adult at 18 for purposes of criminal responsibility and military service, how can we justify treating them as not adult enough to exercise Second Amendment rights? That is a question courts are going to have to grapple with. Let me bring this to a conclusion. The federal law prohibiting handgun sales to 18 to 20-year-olds has been in place since 1968. For over 50 years, it has been accepted as a reasonable restriction. But the Supreme Court's Bruen decision changed the rules. Now, gun laws have to be justified by historical tradition, not just modern policy preferences. And there is no historical tradition of treating young adults as second-class citizens when it comes to gun rights. So this law is being challenged, and it is facing serious constitutional problems. If it gets struck down, millions of young adults will gain the ability to purchase handguns for the first time. States may try to impose their own age restrictions, but those will face the same legal challenges. We are potentially looking at a future where 18-year-olds have full Second Amendment rights across the board. Whether you think that is a good thing or a bad thing, it is important to understand that this is where the law is heading. Courts are taking the Second Amendment seriously, and they are striking down restrictions that cannot be justified by historical tradition. This age restriction is likely the next to fall. Thank you so much for watching. If you found this valuable, hit that like button one more time, subscribe for more coverage of these developing cases, and share this with your friends. I will see you in the next video. Stay informed and know your rights.